Welcome to episode 19 of Quadocast entitled Kiss It Goodbye Laws. Unfortunately, we're starting to live in a community where some people think the bylaws is just something to wipe their ass with. It's an important part of our governing documents, and they've been violated with increasing frequency around here. There has been an emerging attitude in recent years among some board members that play a game of heads I win, tails you lose, by applying the letter of the law only when it benefits them, and only the spirit of the law when it benefits them. For instance, take the settlement agreement between REC and Catania, which states we cannot have a president for both associations, a tower and REC, with a tiny loophole that one could be president of REC if no one else wants the position. And that's why we have Lewis being the president of two associations right now, Britannia and REC. What was interesting was the very first REC meeting he held, and the very first 5 minutes of that meeting, when he went out of his way to ask everyone on the board if they wanted the job. He wanted to make it so abundantly clear that the only reason he's president is because no one else wanted it. So technically, to the letter of the law, he could pull it off. But then what's the point of the law of putting it in the settlement agreement to begin with? The associations came together, put their foot down, and said enough based on the history of their more times than not being a president of two associations. Lewis had an opportunity, a choice, do the right thing and step down from Britannia to honor the spirit of the law, lead by example, change the culture so we could finally turn the page of too much concentration of power. But it is so evident by his actions that he couldn't get enough of it. Just another added to the long list of benevolent dictators. Before we take a look at some of the bylaws that have been or on the cusp of being violated, let's talk about the qualities of leadership, particularly in being president, the face of the place, the liaison. One leadership quality could be one who's mature, under emotional control, stays cool, calm, and collected. But a little known fact, it appears Lewis's charm in some cases can make a small child cry, scared and clinging to his mother, according to an amended complaint from the restaurant lawsuit, filing tortious interference against Lewis personally. And you think he's going to pick up the tab for that? Yet one more thing we're all wind up paying for. The lawsuit reads that Lewis yelled at the restaurant manager in front of a prospect and her small child, shouting that it's not allowed to be on the premises, and that Lewis used swear words in front of a kid. Kid was scared, clinging to his mom, and with screenshots showing this. Well, that's the claim anyway. I don't know all the mumbo jumbo if you have to call it alleged or what. Is that the example of leadership we want around here? Is that the face to the place we want? It's not a one-off. There have been plenty of observed outbursts from him. Moving on, we actually have a first in Quadomain history from Lewis this year. He is the first to single-handedly violate bylaws of two different associations, both Britannia and REC. Both associations state that you must give no less than 30 days notice for the annual budget meeting. Though 718 statute says at least 14 days, not less than 30 days also happens to be at least 14 days, so there's no conflict of interest. Therefore, the bylaws rule. 718 would only supersede if there was a conflict, but there isn't. So who cares about a notice? It's small, it's minor, not the end of the world. And though I could definitely understand someone thinking that way, it's not so much the violation itself, but rather the response when I brought it to board members' attention. Lewis's reply was like insult to injury, saying that he has the option to choose 14 or 30 days, that it's the board's prerogative. What makes sense? Unfortunately, that does not even pass the common sense test. I believe it to be a unilateral made-up fiction by Lewis. But he goes further, claiming the association attorney backs him up. And 3.5 months later, this is still pending unresolved by wasting time sending documents claiming to have an answer, which it still remains silent on. We're talking about on REC. I don't even know if anyone in Britannia even challenged it. But the big picture, real takeaway of all this, if a president could unilaterally make shit up and be left unchecked on something so trivial and small that he would have no hesitance in using association money to defend his fantasy, what does that say when there are bigger violations and bigger problems? That's one slippery slope none of us need. Most any normal president would abide by the governing documents, or if those docs became a burden to the community, the solution is simple: to amend them. But unfortunately, around here, the path of least resistance is to violate them. In the last episode, episode 18, The Root of All Legal Revisited, I refrained from commentary on the quagmire that Britannia is in regarding to a 1986 amendment to their bylaws, which simply states a spouse cannot concurrently serve on the board, period. What is currently known, Lewis got a legal opinion for it and is holding it confidential from everyone. Guess who paid for that opinion? All the unit owners. What is also known as the Britannia manager had read it. What is unclear is whether other board members had received or read it. There is only one exception to keep it confidential, and that is if it was written for the express purpose of litigation or the anticipation of litigation. First question I have is whether the association attorney knows that it's being kept confidential from everyone. Without even knowing the content of the opinion on the 1986 amendment of concurrent spouse serving, think about the unnecessary risk that's created by the act of keeping it confidential, which in of itself might very well be a violation. If the opinion supports a spouse concurrently serving, you'd think he'd be the first one to tell everyone. Let's take the case if the opinion is adverse, and the further case that one or more board members have seen it and knows it's adverse. You know what that would be? That would be collusion. But the manager would have most to lose with a license on the line. Any normal president would have recused. They would have had the manager or another board member deal with the attorney and give the results to everyone, for better or worse. His choice is yet one more example of how he does not rise to the challenge to do the right thing. And it creates risk to everyone in his vicinity, everyone around him. Unnecessary risk. That decision is revealing. First off, it's selfish. Second, it's a feeble attempt to keep control at any cost. In the case that it is adverse, it disenfranchises another unit owner from serving on the board. Not only does it disrespect all the unit owners today, but it spits on the graves of the unit owners 40 years ago who voted for it and decided it to be that way. Have the decency to respect those that came before you. But just like in rec, he's playing the same game with Britannia, which is the path of least resistance. If a majority of unit owners feel it's antiquated and should be changed, well, then you go through the process and amend the bylaws. But it's more than just Lewis pretending, as it's become the unspoken taboo of Britannia. Some have scoffed at it, others feel it's too sensitive of a matter. They'd both be missing the point, unless they too don't care about abiding by the governing documents. Remember, this is all big if, since the content of that legal opinion is unknown to the rest of the unit owners. But getting back to the possibility of collusion because other board members have knowledge, and the event that it is an adverse opinion and they have knowledge of it, they're also candidates running for an election, which is a source to raise more doubt. All unnecessary, by the way. And this is precisely what I'd been warning about, talking about the bigger issue between the relationship of a board and the attorneys. When you have a situation like this, so isolated and contained to the point the lawyer doesn't even know what's going on. Where's the whistleblower exception to any board members who might want out? Instead, they're just rearranging the deck chairs on the Titanic. If it was a nothing burger, it wouldn't be confidential. I suspect the odds favor its adverse, not just by the desperate act of keeping it confidential, but also supported by something Lewis wrote, giving a fiction about how the condo docs were written in the late 1960s. That is false. Quadocast Corp didn't come into existence until the summer of 1972. Actually, I'm going to read aloud his storytelling because it's both bizarre and fascinating. He says, if you read our documents, the reference to man is quite prevalent with a lot of references to he or him, because refusing to sell an apartment to a woman was perfectly legal until 1974. Who cares? We're talking about a 1986 amendment 12 years later. By this time, we already had people living in Grenoble and Valencia. He's just making it up, just stuff out of his mouth. At the very same time, the reference to a spouse referred to the woman who was basically expected to remain in the house unheard and unseen. Listen to this fiction. Spouse has hundreds of years of history, simply means to pledge. He's giving a socio-historical opinion piece from his lens of women expected to remain in the house unheard and unseen in the year 1986. Are you kidding me? A spouse in law referred to the other in a marriage. Then he writes, fast forward to today, the family structure is as varied as there are opinions. However, the universal truth is that we all remain out of the personal affairs of our neighbors. He writes all this to predicate the fact that there's obsolete procedures and antiquated language, and seeking for a document review and an update. Well, this is the one thing I agree on. Yeah, if this one issue is something the majority wants to amend, go for it. One could also view this as a way for setting up a defense on defining what the word spouse is in the year 1986. But if the amendment is a nothing burger, why would the documents need to be updated at all? Why bring it up? Well, Shakespeare told us 500 years ago, it's just a case of doth the lady protest too much? His choice to keep it confidential, which misapplies the confidentiality clause, has done nothing but thrown doubt on this. Thrown doubt on other board members and their candidacy, doubt on the manager, and it's left unit owners, as usual, in a vacuum of silence to try to answer the question themselves. I recall one unit owner mentioning how they used AI to decide and believe that somehow the spouse thing is a non-issue. So as you know, I'm kind of a find out for myself kind of person, so I ran it through AI, and here's what it came up with. I wrote, does the statute 718 use the word spouse when it comes to running or serving on a board? And it replies, based on the research of statute, it does not explicitly use the word spouse when addressing the eligibility of individuals to run or serve on a condo board. However, it does address the concept of co-owners, which frequently applies to spouses. However, Lewis and spouse, who are both right now concurrently serving on the board and should not solely own their units separately, they are not co-owners. Therefore, it is not applicable. The simple fact is 718 is silent on spousal relationship, and because of it's silent, it does not conflict with the bylaws, and therefore it does not supersede the bylaws. The real question is, what happened in the mid-80s for the will of a majority of folks in Britannia go out of their way to vote to put the amendment in there in the first place? Though an answer is not known, the most reasoned speculation is that when Britannia got finished in the early 80s, there is factual evidence of several married couples owning 4 or 5 units apiece bought straight from the developer. That is public information in Broward County. What is uncertain is what happened in the few years before 86 that led up to it. Was there a situation where both spouses were currently serving, or there was a fear that that was most likely to happen because of so many units concentrated in the hands of a few, that a majority of the community wanted preventative measures and voted for it? This is no longer about Lewis. He's a known quantity. You know, the guy that's held only 4 board meetings in both associations across the near year term he's had it, or all the Porticashare games being played to the point where Catania's ready to charge us $500 a day over it, or overworking rec staff to death in the last month and a half during election season to make up for all the lost time and do a year's work in a month, or wasting crazy money on legal trying to get money back from a company that went bankrupt, or maybe just his charm that makes toddlers cry. To the unit owners of Britannia, please show us what you're made of and that you could lead the change we desperately need here, and to bring in new people on the board so we can have more responsible, steady stewardship that we need here, especially on rec. So who are you going to kiss goodbye? Lewis and most of the board, or your bylaws? You make the wrong choice and you'll be left with nothing but the Britannia bylaw bamboozle, which I hope for everyone's sake does not happen. And on that note, wishing everyone a great week ahead.